Thank you, and thank you all for joining us. And whether you're here to ignite endorphins or learn about receivership practice, you're in the right place. This is Digging Deeper in Asset Recovery and Distribution, which is episode number 3 of the Financial Poise Federal Equity Receivership Series. You can read more about Financial Poise and Daily DAC on slides 2, 40, and 47. Our panelists for today are Kathy Bezoyan-Phelps of Raines Feldman Luttrell, Chip Hobeke of Raymond, Jonathan Perlman of Venable, Melanie Vardabedian of Ballard Spahr. My name is Kevin Duff. I'm with Rackless, Duff & Peel. You can see our names on slide 7, which I've just put up for you. You can read our bios on slides 35 through 39. I'm not going to look at those right now. Neither Financial Poise nor we intend this program to be a sleep aid, so you don't have to listen to me read bios. If you want to learn more information about us, just look at the bio slides. About the slides, I'll try to call your attention to certain slides as we're going through our program that are relevant to whatever we're discussing. And you can take notes if you like, but don't worry, if you're listening but not watching this webinar, you'll be just fine because the slides are not critical. Thank you to our co-producer, the National Association of Federal Equity Receivers, which is known throughout the receivership world as NAFER. You can read more about NAFER on slides 3 and 46 through 44 through 46. Financial Poise Webinars is supported in part by sponsors, and the sponsors for this webinar are Sunburst Digital, maker of Type to Learn, the #1 typing app for children K through 12, and Max Asset. If you need to conduct an online auction, Max Asset is your turnkey solution. Sunburst and Max Asset are both highlighted on slide 4. Additionally, sponsoring is Mood, the nation's #1 premier online retail cannabis dispensary, and more information about Mood is on slide 5. The last thing before we begin is to direct your attention to slide 6, which contains a disclaimer. You're not our clients. We're not your lawyers, accountants, ologists of any kind, or other advisors. What we're here to do today is simply for your general education and not for you to act upon without appropriate advice from retained professionals. So now it's time to pull back the curtain on asset recovery and distribution. You should grab some popcorn and your favorite beverage. And while we regale you with musings and tales from the receivership universe or multiverse. So Chip, if you could start us off, we'd like to just start by talking about an overview of what a fraudulent transfer is and what avoidance actions are.
I'll start off at the very, very high level and then hand it off to the real experts in a second. In almost all of these cases, someone's gotten something they shouldn't have gotten. Either they took it and transferred it themselves, or there's someone who got something that they shouldn't have gotten. Oftentimes it's cash, it could be property, it could be releases from actions or causes of actions or all sorts of things. But the way that a receiver gets those valuable assets back into the estate that they're taking care of is through what we generally refer to as a fraudulent transfer and avoidance action. It's simply the most common claim a receiver asserts against third parties to get stuff back into the estates. The receiver stands in the shoes of the creditors for purposes of the claim. Ultimately, it's trying to bring these assets back in so that the distribution scheme can more appropriately distribute the entire body of the assets of the receivership entity out to the creditors who are entitled to them, rather than those people who got them and shouldn't have in the first place.
Thank you, Chip. Kathy, what is a constructive fraudulent transfer and what's an actual fraudulent transfer?
Sure, thanks, Kevin. Well, fraudulent transfer theory involves really 2 pretty distinct types of claims to avoid and recover and bring back in things, whether it's cash or property, as Chip said, that's been transferred away. One theory is an actual fraudulent intent theory. The other one is called constructive fraudulent transfers. And these really generate under state law under what used to be called the Uniform Fraudulent Transfer Act. It has been revised in the past couple of years. Now it's called the Uniform Voidable Transaction Act. Interestingly, the word fraudulent was taken out of the title because it was a little bit of a misnomer and caused people who are getting sued for fraudulent transfer to freak out that they had somehow been engaged in the fraud, which they don't have to have been, they just happened to have received the property. So each state has or hasn't adopted the Uniform Voidable Transaction Act. I'll call it the UVTA. Most have, if not all of them. And there are some key provisions in the UVTA under an actual fraud theory about how to evaluate intent, and there's badges of fraud, which we'll talk about. There are expanded remedies under the UVTA, which provides maybe even the ability to obtain attorney's fees and costs. There are statute of limitations, the basic one being you can look back 4 years. Some states have expanded that maybe up to 7 years. And then there are certain defenses that we'll talk about today as well that the recipient of funds can assert as well. So under an actual fraudulent intent theory, this really means that the transferor, the one making the transfer, had the intent to hinder, delay, or defraud any creditor of the debtor. And again, in determining whether that actual intent exists, you look at the intent of the one transferring, and there are certain factors to be considered, which we'll dive a little deeper and we'll talk about that. So the intent of the transferee, whoever received this money, is really irrelevant to the whole analysis. And you often look at sort of the totality of the circumstances. This type of theory is very similar to a theory under the bankruptcy code for actual fraudulent intent under section 548A1A. And again, proof of the intent is going to depend on the facts and circumstances surrounding that particular transfer on a case-by-case basis. Constructive fraudulent transfer doesn't involve intent at all. And this is really looking at when something was transferred, whether it was transferred for really kind of a grossly inadequate consideration that came back. So you just gave something away and there was no value that came back. And there's really sort of two primary things involved as a prima facie element for this type of claim. One is in exchange for the transfer, the debtor received less than, the term is reasonably equivalent value, and we'll talk a little bit more about what that means. And also you look at the financial condition of the debtor, the one that was transferring the property. And there's a few different ways to look at that. Number one, were they insolvent on the date that the transfer was made or an obligation was incurred? Or were they engaged in business or a transaction or about to engage in business or a transaction for which any remaining property was really an unreasonably small amount of capital? Or did the debtor believe that they would incur debts beyond the debtor's ability to repay them? So you look at all those, or was a transfer made for the financial benefit of the insider of the company? So again, intent is irrelevant, and you're really looking at the value going back and forth. So they're very two distinct theories of liability on fraudulent transfers.
Thank you, Kathy. Melanie, Kathy mentioned badges of fraud. When we're thinking in terms of the traditional indicia of fraud, what would that entail?
Thanks, Kevin. Happy to address that. So to start, the bankruptcy code does not explicitly list badges of fraud, but the Fifth Circuit has recognized the following badges of fraud in analyzing actual fraud under the bankruptcy code. And those are the lack or inadequacy of consideration, if there was a family, friendship, or other close associate relationship between the parties, the retention of possession, benefit, or use of the property in question, the financial condition of the party sought to be charged both before and after the transaction in question, the existence or cumulative effect of the pattern or series of transactions or course of conduct after incurring the debt, such as onset of financial difficulties or pendency or threat of suits by creditors, and the general chronology of events and transactions under inquiry. The badges of fraud that may be considered to find actual intent on the part of a debtor can vary by state, but they may include things like what's listed on this slide. The transfer obligation was to an insider, the retained possession or control of the property transferred after the transfer obligation was concealed before the transfer was made or obligation was incurred, the debtor had been sued or threatened with suit, and it goes on. And I won't bore you by reading everything on the slide, but those are generally the badges of fraud that can be utilized for actual fraud.
Thank you, Melanie. Jonathan, can you tell us what reasonably equivalent value is for purposes of analyzing an avoidance claim based on constructive fraud? And are there differences or different approaches to that determination?
Kevin, I'd be happy to, but something you said at the beginning is actually pretty prescient when you mentioned the receivership multiverse. I think the thing that practitioners need to be aware of here is it does indeed matter where you are, what court you're in, whether you're in bankruptcy court, whether you're in a district court, and the statute or the bankruptcy code 548 A1B that we're talking about. And it's like being in different universes, and how this is going to play out and what reasonably equivalent value even means is different in all these different places. And one of the reasons is because the bankruptcy code, for example, doesn't define reasonably equivalent value. And in truth, most state statutes don't define reasonably equivalent value as well. It might be that when all of you hear that, when we hear that word, we go, oh, it's pretty obvious. If you paid $100 for something that's worth $100 on the market, then it's reasonably equivalent value. But it often doesn't play that way. If you have a Ponzi and you paid market value for the services, is that it? And now you don't have to do you don't have a claim where you can avoid a transfer under the constructive fraud theory? Does it matter if the market rate payments are intended and designed to harm the debtor and to harm the creditors? Meaning, are they designed to solicit investors into being defrauded, into entering the scheme? Does it matter if the payments are for advertising the Ponzi to investors? Does it matter if the payments, the transfers, are for telemarketing sales services to solicit investors? Or is it just because you paid what the going rate, you've satisfied reasonably equivalent value? As Kathy mentioned, these kind of things have historically been evaluated on a case-by-case basis, taking into account subjective and objective factors, some of which include the good faith of the party, some of which include the market value, some of whether the transfer was truly in furtherance of the Ponzi and increased its insolvency, and therefore was to the detriment of the creditors. Some just look at hypothetical creditor. Would a creditor, since you're in fair market value, have been benefited by the payment for the services? If you look at the slides we have up there, one seminal decision is the JMV versus Golf Channel case. It's the second item on the slide. And that's a great case because it was a federal receivership case where Stanford, a big Ponzi scheme, paid millions of dollars to the Golf Channel. The Golf Channel provided advertising. The advertising was aimed at recruiting investors into this big Ponzi scheme. The receiver sued Golf Channel in federal court under the Texas Uniform Fraudulent Transfer Act, TUFTA, to recover the channels and to recover the transfers. And Golf Channel argued, as it should, that the payments were for reasonably equivalent value because they were paid from Stanford the same as they would have been paid by anyone else. The Fifth Circuit originally held the payments were not for value, much less reasonably equivalent value, because the advertising services, their purpose and effect was to lure victims into the Ponzi, and it necessarily rendered Stanford, the debtor, more insolvent. Thus, objectively, they didn't benefit Stanford's creditors at all. Sounds like an objective test. But then they decided to go on rehearing and certify it to the Texas Supreme Court. Texas Supreme Court, who has the ultimate say under the Texas Uniform Fraudulent Transfer Act, said exactly the opposite. They said on the issue of whether transfers had objective value under Texas's statute, the transfer does not depend on whether the debtor was operating a Ponzi scheme, so long as the services would have been available to another buyer at market rates had they not been purchased by the Ponzi debtor. So under that statute, everything else becomes irrelevant. If it's a service or good that has a market value and you paid the market value, that's all that matters. But when it went back to the Fifth Circuit applied that, but they also specifically recognized that the TUFTA, the Texas language, was unique amongst the state fraudulent transfer laws because it had a sentence that specifically defined reasonably equivalent value as anything that's market value. And the court, the Fifth Circuit Court, said it would continue to apply the opposite rule in bankruptcy cases, and it cited the Warfield case. It noted that in the Northern District of Illinois, they also apply the opposite test being, hey, if this is something that clearly is going to necessarily be in furtherance of the Ponzi and harm the debtor and harm the debtor's creditors, then it can't be reasonably equivalent value. The 11th Circuit, another one of our multiverses, has said exactly the opposite in bankruptcy cases twice, including one Ponzi case, saying, nope, if there's a market value for this good or services, that's all you look at. And we just care about the market value and whether a hypothetical creditor, not the actual creditors who were clearly going to be harmed, matter. Takeaway, know your operative statute and know the court you're in.
Yeah, it sounds like indeed, Jonathan, there could be differences that vary by state, by statute, and you have to know them. Chip, when we're talking in terms of actual fraud, are there any defenses that can be asserted to an assertion of actual fraud?
There are defenses. Just like Jonathan mentioned, where you're at matters. But generally speaking, there's a couple of things that are going to play in your favor no matter what. The first one, and this might be a hard target to hit, it's a narrow window, but did you receive the transfer in good faith? Honesty in fact, without notice of any suspicious facts that would have given rise to a duty to investigate. It happens. But lots of the circumstances we're talking about are not these. So when there's transfers to insiders, you probably don't have the receipt in good faith argument, for example. Many of the badges of fraud are things that are used to take a look at whether or not this receipt in good faith could be met. And those badges of fraud tend to disqualify most parties from it. The other piece, though, is the exchange of reasonably equivalent value. And that's a pretty important thing. If there was not reasonably equivalent value, you definitely got a problem. If there was reasonably equivalent value, especially in very subjective circumstances, then this can be something that can be a defense that can be at least raised to muddy the water a bit. You saw this back, for example, in 2007 and 8, when real estate crashed, when there was such volatility in prices, and you had transfers of property. There was a lot of argument about what reasonably equivalent value was during those turbulent times, and it certainly gave rise to defenses and certainly created plenty of funding for litigators.
Can I add on a little bit to the discussion here? Kevin, you asked your question about whether there are any defenses to an actual fraudulent transfer. The UVTA actually provides for a good faith value defense for all kinds of fraudulent transfers, including constructive fraudulent transfer. And I just want to point out that you need both. It can't be just good faith or just value. You need both. And it's very interesting to see the good faith value defense play itself out depending on which type of fraudulent transfer claim you're talking about. And let me just give a hypothetical. So in a Ponzi scheme case, for example, if an investor invests $100,000 and they get back over the course of the scheme maybe $150,000, they've made a $50,000 profit. On an actual fraudulent transfer theory, the receiver is entitled to go after the entirety of the money that they got back, the full $150,000. If that defendant can assert that they got it in good faith and there was value, The value that they provided was the 100,000 that they put in, not the full $150,000. So they're, even if they can establish good faith, they're still going to be exposed for $50,000 of profits that they receive. On a constructive fraudulent transfer, again, you've got your reasonably equivalent value element as a prima facie element of that claim, and that's going to take them up to the 100,000 that they invested. They're still exposed for the $50,000. If they can't establish good faith, then the entirety of the transfer that was made is subject to recovery.
So it sounds like one is going to need to look not only to bankruptcy law, but to your state fraudulent transfer statutes and undoubtedly to the case law in your jurisdiction to see how those are interpreted. But thank you for adding that point, Kathy. Jonathan, this raises an interesting question, I think, that sometimes arises in litigation, which is when a good faith defense has been asserted, what is the reach of that, right? On the one hand, it goes obviously to the issue of whether or not there has been a fraudulent transfer. But when it's asserted, can there be other implications? And here I'm specifically going to direct you to the impact it could have on an assertion or protection of an attorney-client privilege. What are your thoughts about that?
Well, it does have an impact, and it does raise some strategic opportunities for the opposing side. That case that's on the bottom listed on the slide, Welch v. Regions Bank, it's actually the seminal decision on this issue. And there's a doctrine that most attorneys are aware of called the at issue doctrine, which is attorney-client privilege is pretty sacrosanct. Generally, you do not have to turn over documents that reveal advice you received from your counsel. But under that doctrine, which is an equitable doctrine, a party should not be able to use the attorney-client privilege both as a sword and a shield. So as a result of this doctrine, if a party injects a new issue affirmatively into a case, and right now we're talking about good faith, if you assert good faith as a legal affirmative defense to a claim someone is asserting at you to avoid or recover upon a transfer, you've now injected an issue into the case. And if the only evidence of your good faith, of whether you truly acted in good faith, is going, or the most substantial probative evidence is going to be communications that are attorney-client privilege, Welch v. Regions Bank, we actually represented the trustee in that case, holds that those attorney-client communications, to the extent they reveal your intent and that whether you were in good faith or not, becomes waived by your assertion of the affirmative defense. And that's exactly what happened in Regions Bank. We got the attorney-client privilege waived for those documents, which they had to turn over. Interestingly, the court in that case limited the waiver to the specific documents that the judge in camera said were most probative of the good faith intent, which is a little different than the general rule that a waiver of privilege waives the privilege for all documents. But that's how that case went, and it is the seminal decision.
Thank you, Jonathan. So oftentimes where we see these issues of fraudulent transfers arising, or instances where receivers and their professionals have to go and engage in asset recovery, we sort of popularly hear that those are frequently in Ponzi schemes. Melanie, to sort of ground us on that concept, could you tell us what a Ponzi scheme is? And can you recover fraudulent transfers in a Ponzi scheme case?
Sure. So to start, a Ponzi scheme is a fraudulent investment operation where the operator generates returns for older investors through revenue that is paid by new investors rather than from legitimate business activities or profits of financial trading. One of the most notorious examples of a recent Ponzi scheme that I'm sure everyone has heard about was perpetrated by Bernie Madoff. And sometimes we use shorthand ways of describing Ponzi schemes like robbing Peter to pay Paul or something like that, that just refers to this idea of the older investors are getting paid not because of legitimate operations of the company or the purported wildly successful investments, right, that Mr. Madoff said that he was making. No, it's because of new investors that are coming in, putting their funds with the Ponzi scheme perpetrator. That is what is actually getting paid to the older investors. And Kevin, to answer the question about whether a receiver or trustee can recover fraudulent transfers in a Ponzi scheme case, yes, absolutely. And sometimes those are actually the only source of recovery. And whether or not a judge in a case deems the operation to be a Ponzi scheme is actually a very important, is an important ruling in a case. And we'll talk more about that later, but it's because there will then be a Ponzi presumption that inures to the benefit of the trustee or receiver if that determination is made by the judge. But going back to fraudulent transfer lawsuits and Ponzi scheme cases, generally targets of fraudulent transfer actions might include funds that were transferred to investors, so profits that were made, that were paid to investors, often older investors, right, by new investor money. Sometimes these are called fictitious profits. Also, another kind of fraudulent transfer or avoidable transaction lawsuit that might be filed is commissions paid to salespeople or broker-dealers who solicited the investments. Of course, transfers to friends and family, donations to charitable organizations. I'm located in the state of Utah. We have a fair amount of Ponzi scheme activity here, unfortunately, and lawsuits against the LDS Church for fraudulent transfer are not uncommon here because often it is found that the perpetrator of the fraud was making donations to the LDS Church or to his church for charitable purposes. And then fees paid to professionals are another area where there is a target for a fraudulent or voidable transfer lawsuit. Kathy and others have already gone over this, but just again, of course, the statutes provide for two types of fraudulent transfer: constructive fraudulent transfer and actual fraudulent transfer. It was stated earlier, people are often surprised that they can be liable under these statutes even where they had no knowledge, they didn't believe that they participated in the fraud, that they were just sort of additional innocent victims of the fraudulent scheme. But the law does compel them to return profits when when people do get mixed up in a situation like this. So under constructive fraud, a person that receives funds is only liable to return profits, not principal, because the principal is generally considered reasonably equivalent value that was provided by the investor or the victim. Whereas under actual fraud, the receiver can recover fictitious profits and principal transferred to investors in the Ponzi scheme. And if actual fraud is proven, the defenses available are that the investor has to show that he took for value and in good faith, as was discussed earlier.
So Chip, in instances when a Ponzi scheme is present, what are the elements that the participants, the parties, the court are going to be looking at to determine whether or not a Ponzi scheme is entitled to the presumption that we've discussed, and what other factors and we'll be discussing, and what other factors might a court consider? And I guess what I'll ask you as well in connection with that is, if you have any sort of a story or vignette that might punctuate that, when a scheme has the trappings of a Ponzi scheme, that would be helpful.
Kevin, a lot of factors are considered by the various courts. One of the top ones is this promise of large returns with little risk. And boy, even though the too good to be true axiom is in play, many people, many institutions get caught up in something that should have sounded too good to be true. After the fact, many people look back and say, I should have known. That's one of the factors the courts take a look at is, does it make sense? Knowing what we know about investment returns and risk, and the crazy returns tend to come with crazy risks. The low risk, high returns, usually something fishy with. That's one of the big factors they look at. A second factor, which is key, is how are the old investors paid? Are the old investors paid out of actual operations, or are they simply paid out of new investors' money? Are there any legitimate business operations? This sometimes can become confusing. At times you have a mixture of Ponzi-like operations and some real operations. Perhaps something started off with real investments, and as trouble happened in that investment world, the older investors started being paid by new investors, and so it can be a little fuzzy, but you see that Ponzi factor of eventually the older investors being paid by new ones come to light. Is there commingling of investor funds? Are there customer funds used for non-customer purposes? Do we have inconsistencies between operations statements and actual bank statements or reports? Are there fictitious values that are out there, where you either just flat out don't have an investment, or an investment is overvalued, or returns are overvalued or misstated? Those sorts of factors come into play. And it should be mentioned that, many of these factors are in just regular fraudulent enterprises, which aren't always Ponzi's, but these are the sorts of things that are considered. In terms of a personal example, I actually had a grandmother-in-law early in my marriage who gave my wife and I a call and said she'd met this really great guy at church, and she and Grandpa had invested $5,000 because he promised to pay him $25,000 within 30 days, and sure enough, he had, and wondered if there were any other family members that she knew that might want to also invest. Even though I was younger, it did smell too good to be true. So we stayed away from it. But sure enough, before long, Grandma got to meet members of law enforcement, and indeed had to give back the extra 20,000. She got to keep the 5 that was her original investment. But those are the sorts of things which, again, especially in hindsight, when these tests are applied and looked at, it's pretty easy to tell when there's a Ponzi.
Yeah, I'll tell you, and the too good to be true is really an appropriate label, and folks ought to be aware of that. And when you hear about these things, be aware, be alert, and don't hesitate to second guess, right? So Kathy, I mentioned earlier, or made reference to the Ponzi presumption. Can you tell us more in more detail what that is, and the types of transfers that would be entitled to that type of presumption? And also, can a Ponzi presumption be applied in a case that's not really a Ponzi scheme?
Sure. Just tacking on to Chip's explanation of what is a Ponzi scheme. And I hate to do this because it's a plug, but I also I care about investors not investing in Ponzi schemes. I actually have written a book called Ponzi Proof Your Investments: An Investor's Guide to Avoid Investing in a Ponzi Scheme or Other Fraudulent Scams. And it is a book written at a fairly basic level about all of the red flags and with specific due diligence questions that you can ask to avoid investing in a Ponzi scheme. Because once you're familiar with a Ponzi scheme, the red flag warning signs are really quite evident. So I just throw that out there if anyone is interested in pursuing that, if you're questioning and wanting to vet a particular investment opportunity. The Ponzi scheme presumption, what is it and why do we care about it, really is a question. And this is a presumption that a court can legally impose on a situation to say that a particular transfer, and again, we're talking about fraudulent transfer liability here, where a receiver is trying to recover and bring back some money, the receiver has to prove certain things. And on an actual fraudulent intent claim, the receiver has to prove that the transfer was made with actual fraudulent intent. Well, courts have found that if you can establish something is a Ponzi scheme, which itself is not defined, then there is a presumption that that transfer was made with that actual fraudulent intent. And so the receiver can check the box and say, I've established that prima facie element of this claim bring me that money back in. Well, and sometimes there's a question of, is it easier to establish that something is a Ponzi scheme, or is it easier to separately establish the actual fraudulent intent through the badges of fraud analysis that Melanie talked about a little bit? So the reason why we care about it is because it really eases the burden potentially for a plaintiff in pursuing a fraudulent transfer claim. The concept is that there's this presumption that a transfer of property made by a debtor in furtherance of a Ponzi scheme is a transfer made with fraudulent intent. There's no other explanation possible, and therefore you've established that element. If you get a Ponzi scheme presumption because you've gone through what Chip talked about in terms of establishing that there is a Ponzi scheme, that is a pleading advantage, but it's not ultimately a final determination of liability because it's subject to rebuttal by a defendant. I will tell you, in all of my years of experience, I've never seen anyone seriously try to rebut a Ponzi scheme presumption. There are ways to try to limit the use of the Ponzi scheme presumption. So there's two critical elements that have to be established. One, you have to establish the existence of a Ponzi scheme at the time of the transfer. So sometimes you see people come in and say, this was legitimate and it morphed into a Ponzi scheme. And when I got my transfer, it wasn't yet a Ponzi scheme, which is, potentially a valid defense. The other is that the presumption will only apply to transfers that are made, the lingo is, in furtherance of the Ponzi scheme. So that can also really narrow the use of the Ponzi scheme presumption. There was an interesting case a number of years ago in the Thomas Petters case, where the bankruptcy trustee, it wasn't a receiver in that case, went beyond just trying to seek to recover from the investors who had received profits, but had different types of classes of defendants that they were suing. They sued a number of the lenders who had lent money to the debtor, to Petters. They sued the recipients of charitable contribution. And the trustee also served the employees of the debtor who had received not only salary, but certain bonuses or commissions. And so the question really that the court looked at very closely there was, were these transfers made in furtherance of the Ponzi scheme? And it was interesting to read the analysis. And at the motion to dismiss phase, the court said, yes, the trustee had established this. But for example, the lenders had infused capital into this company to allow it to pay earlier investors, and earlier lenders then had a means to avoid default, and that sustained the whole facade of the Ponzi scheme. So that passed the initial threshold of, yeah, those transfers are back to the lenders arguably were made in furtherance of the Ponzi scheme. Same thing with respect to the charitable contributions, right? That enhanced Petters' credibility in that case in luring in other investors. Same thing with the employees, right? They kept the employees on board. Those employees continued to run the scheme because they were getting paid, and they were getting paid bonuses, and they were getting paid their salaries. So arguably those were transfers made in furtherance of the Ponzi scheme. I will tell you that as time has gone on with the Ponzi scheme presumption, I have seen courts narrow the use of it a little bit. Initially when it first came out, there was this thinking that, oh, it's a Ponzi scheme, so everything is subject to the Ponzi scheme presumption. And that might include payment to the landlord for the facility, payment to the janitor to clean the toilets, right? Rather than payments to investors or the people that were running the scheme, to the insiders. I have had a case recently in which the perpetrator of the scheme pled guilty and said I was running a Ponzi scheme. But there were a couple of elements to the business. There was one that was a legitimate part of the business where they had a physical store location and they were selling wine and they got money for the wine. Another was sort of the Ponzi scheme component of it where they were selling futures in wines, right? But selling the same futures multiple times, right? So there was a whole scheme going there. And the plea agreement involved the Ponzi scheme aspect of it, but not the legitimate aspect of it. And I actually filed a summary judgment motion seeking to apply the Ponzi scheme presumption over some particular transfers that had been made. And the court initially denied that and said, I can't tell whether the plea agreement and the Ponzi scheme guilty plea applies to these particular transactions. So I don't want to cast a wide net of the Ponzi scheme presumption over every single transfer that was made, you need to prove to me, bankruptcy trustee, that these particular transfers fell within the Ponzi scheme. Otherwise, you got to go through traditional badges of fraud analysis. So I filed a second summary judgment motion, did a badges of fraud analysis, and got the relief that I wanted, and the transfers were avoided. But it was interesting to me to see a judge very carefully look at whether it was appropriate to impose this presumption over the entirety of the case. I do think you probably need to establish a Ponzi scheme to get a Ponzi scheme presumption. Interestingly, there was one case, Finn versus Alliance Bank in, I think it was Minnesota, that said, we don't think that this Ponzi scheme presumption should be used at all because there's no statutory authority for it. That's the only state that's done that. And I've actually, in California, a court has expressly said, no, that rationale doesn't apply here. This is a judicially created presumption. So, I think when you start to say it's a quasi Ponzi scheme or it's Ponzi-like, it's going to be a lot harder to establish a Ponzi scheme presumption. And then again, you're going to have to show there was a Ponzi scheme, it was in place at the time of the transfer, and that the particular transfer was made in furtherance of that Ponzi scheme that you've established.
Thank you, Kathy. Jonathan, did you have a point you wanted to add on this?
I think Kathy, you just presented just a complete, excellent analysis of this. And for the same reasons, having run into the same issues you have, whenever I'm making the Ponzi presumption argument, whether it's in a true Ponzi, a quasi Ponzi, a business that has Ponzi to it, but also some legitimate aspects, I always present the court with the Ponzi argument. And also I do a badges of fraud analysis so that, well, it's for a couple reasons. It's one, I don't want to have to go back twice. It's two, I'm trying to help ensure that my judge, if they rule for us as receivers, that we're protecting the judge on appeal, so that some appellate court never comes back and says this can't withstand because we've it's a case by case analysis, these things. And also, quite frankly, I've never had a case where it's a Ponzi, as suggested by Chip and Melanie, where multiple badges of fraud don't exist. So that's my strategy on it, and it's served the estates that I have served well.
There's a. Go ahead, Kathy.
Sorry, one other point I forgot to make on the Ponzi scheme presumption is you can use it to establish actual fraudulent intent on an actual fraud type of theory. It can also be used to establish insolvency, which can be useful not only for badges of fraud analysis, but also on a constructive fraudulent transfer claim. Because if you can establish a Ponzi scheme as of a certain date, you can get a presumption that the entity was insolvent, which is a necessary prima facie element of the constructive fraudulent transfer claim.
That's 100% correct.
Yeah, that's right. So for those looking to dig a little deeper, there's an article that was published by NAFER in its publication, The Receiver, in January 2017. It's titled, "It's a Fraud, It's a Scam, It's a Ponzi-like Scheme, the Legal Definition of Labeling a Scheme a Ponzi." It's written by Greg Hayes and Eric Silva. Worth a read, worth a look up. So Jonathan, can you explain the settlement payment defense to a constructively fraudulent transfer under Section 546E?
Sure. Kevin's reference to 546E is the bankruptcy code. And in the bankruptcy code itself, that provision provides that the trustee, because in bankruptcy you have a trustee instead of a receiver, may not avoid a transfer that is a settlement payment made by or to a financial institution or a securities clearing agency. So what that provision is, it's an actual safe harbor that prevents fiduciaries like trustees in bankruptcy cases from avoiding constructively fraudulent transfers to a financial institution. But it only covers two types of payments: margin and settlement payments. And it only includes three types of contract. They got to be in connection with a securities contract, which if you're dealing with a Ponzi and investors, you probably are. Commodity contracts and forward contracts. And again, it only applies in bankruptcy. There's no analog for this language under any of the state fraudulent transfer acts that I've ever seen. So that this defense shouldn't apply to a receiver unless the receiver converts to bankruptcy and there's a trustee in place. And I would also add that in bankruptcy, it applies to preferences and constructive fraudulent transfers, but it doesn't apply to the actual fraud that we've been discussing, which is the other avenue to proceed. There's also a split, by the way, in the circuits. Even in these cases, if the transfer passes through a financial institution and then to a subsequent transferee, can the subsequent transferee, who's not a financial institution, raise the 546 E defense? And as is usual in our multiverse receivership and bankruptcy trustee world, the answer is it depends where you are. The 7th Circuit and 11th Circuits say no, but the 2nd, 3rd, 6th, 8th, and 10th Circuits say yes, that the final transferee can raise that defense when there's been an intermediate financial institution.
So we've been spending a lot of time talking about Ponzi cases and fraudulent transfers. Let's shift over a little bit, Melanie, and talk about some of the types of claims that a receiver or trustee could bring against, let's say, professionals or others, insiders or whatnot, where they can be accused of helping to perpetrate the scheme or assisting the fraudsters. Can you explain what an aiding and abetting claim is?
Yeah. So aiding and abetting is a tort-based claim that a receiver or trustee could bring against an advisor who helped the fraud be conducted. So examples of the kinds of entities that could get sued for this kind of claim would be a law firm who was representing the fraudster or his entity, accounting firms who provided their services, lenders, equity owners, commission sales agents, officers or directors, people of that nature who in some way assisted the fraudster to perpetrate the fraud and then thereby harmed investors, victims, or creditors. So the elements for aiding and abetting claim are listed on the slide. You have to have the existence of a fiduciary duty, a breach of that duty, a knowing participation in the breach by the advisor. Now, this is, in many cases, the most difficult element to satisfy, because oftentimes these advisors, well, not oftentimes, I mean, they will always say they didn't know, right? That there wasn't, that this was a sophisticated scheme and there was really no way for them to know what was going on, and they were just doing their jobs. So that is the one element that I think does provide the most difficulty for receivers and trustees to prove. And then, of course, damages that were proximately caused by the breach. I've represented like a bank before that got sued for aiding and abetting claim, and financial institutions would argue that they followed the laws, that they had adequate procedures in place, right? That they had no way of knowing that this was a fraudulent scheme. So that's kind of a high-level overview of a aiding and abetting claim, Kevin.
But it's common for those types of claims to be brought in these, especially these complex cases where there's a lot at stake and a lot missing. But also what we see when these types of claims are brought against professionals or others, sometimes the receiver's standing is questioned, sometimes other defenses are raised to try to undermine a receiver or trustee from bringing these types of claims. Chip, tell us a little bit about in pari delicto, because that's a phrase that arises with a fair amount of frequency in these types of actions.
So the idea here is that the law is not going to assist crooks going after crooks who outcrooked the first crook. We don't have assistance for someone who's equally dishonest. And so in this case, the arguments made, the receiver is standing in the shoes of one of the crooks. And so the law should not enable the receiver who's in crooky shoes to be used to go after another crook. Generally speaking, that doesn't apply for receivers. That doesn't hold water. The idea is that with the bad guys removed, the crooks out of the way, no reason to punish the receiver for the bad acts of the prior folks. As a matter of fact, in large case, part of the reason the receiver's there is to correct and make right those bad acts. And so generally speaking, that defense doesn't fit for receivers. Most circuits do, interestingly enough, apply the rule against bankruptcy trustees. So that's an important thing to consider as I suppose if you're someone who's looking at potential remedies and thinking between whether forcing a bankruptcy or trying to get a receiver put in. Not that this is the end all be all, but there's a big difference in the effectiveness of this defense against trustees compared to receivers.
Thanks, Chip. Of course, you know, these cases we frequently talk in terms of the evil zombie have been removed, which is why the receiver can move forward and not be still under the spell that the evil zombie had cast over the corporation. So, Melanie, what are some of the exceptions to the application of the impari delicto defense? And can the impari delicto defense be asserted if a bankruptcy trustee brings an action? If you could comment on that, that would be helpful.
Sure. So yeah, as Chip mentioned, the in pari delicto defense is definitely more powerful and effective in bankruptcy proceedings than in federal and state courts generally. And so this is one of the main reasons that regulatory agencies prefer filing cases in federal and state court rather than bankruptcy courts, among, of course, other reasons that we won't get into now. So this slide has cases standing for the proposition that in pari delicto can be asserted against bankruptcy trustees. There are exceptions here if there's an intervening receivership, adverse interest, or the sole actor doctrine. In my experience, though, it's really not a clear-cut issue. There are risks of a judge, even in a receivership case in a favorable jurisdiction, who could find favor with in pari delicto arguments. So in these instances, oftentimes receivers will seek contingent counsel on tort type claims like aiding and abetting claims, so that risk is spread not just among the receiver and the defrauded investors or victims, but also with counsel.
So we've now spoken about efforts to recover either assets or other money back into the estate, and we get to the point where we need to distribute that money out to the victims and creditors. Kathy, for that, if you would tell us a little bit about what are the factors you'd consider in putting together a distribution plan?
Sure. I mean, the first thing you have to do is look at who your creditors are, who the claimants are. And there can be really a wide variety. You've got maybe your defrauded victims, if it's a fraudulent scheme or a Ponzi scheme, but you have the receiver and the professionals that have unwound the whole mess and recovered the money. You may have tax claims because the bad guys didn't pay their taxes. You may have employee wage claims. You may have just general unsecured creditors, again, your landlord, maybe a breach of contract claim. And so the first thing you have to do is decide what that pecking order is. And there's a real distinction between how a receiver might propose a distribution plan versus what a bankruptcy trustee is compelled to do because of all of the priority scheme in the bankruptcy code. What we find if you've got a regulatory receivership, so for example, the SEC or the CFTC shut a business down, they put a receiver in place, is that they have a strong preference to get money back first to the defrauded victims. Well, first to the receiver and the professionals as administrative claims, and then you have to pay any taxes because receivers can have personal liability if the taxes aren't paid, and then to the defrauded victims. So you often will see other types of creditors subordinated, general unsecured creditors. So that's kind of one of the first things you have to think about. And then when you get to the body of your claims usually are the defrauded victims, then you have to look at those victims and see whether or not there's a reason to distinguish among them. Oftentimes there's not, but sometimes they may have invested into a distinct type of program, and courts may find and receivers may find that there's a reason to think about them separately and to distribute a different pot of money to a different group of investors. So you have to kind of look at your case and see whether everyone is similarly situated or whether there is some basis to consider them separately. Along the same lines, you want to look to see whether everything is hopelessly commingled. And if so, you probably want to treat everybody the same. There are oftentimes going to be investors saying, well, I was the last one to put my money in and I can still see it is still sitting in the bank account, so I want my money ahead of everybody else. And that's like a kind of a constructive trust type of an argument. And oftentimes that won't fly, and a court will say, no, everyone was equally defrauded. You just happened to be the last one, so we're going to treat everybody the same. And so once you sort of have made those preliminary decisions, then you get into what the distribution methodology should look like. And I think we're going to kick that over to Jonathan to talk a little bit more about that.
Indeed. Jonathan, what are the different methodologies a receiver can use for distributing funds? And how does a receiver determine which methodology to use?
Thank you, Kevin. The predominant methods that receivers use and consider are called the net investment method, the rising tide method, and the last statement method. Each has its pros and cons. I've used both the net investment and the rising tide, or some hybrid of them. Never have used last statement. The net investment looks back to the date the entity became a Ponzi. So you take total dollars in minus total dollars out, and you have your net investment. And you generally ignore all interest and profits, which we've discussed are fictitious often. Anyway, the rising tide method, on the other hand, brings all investors to the same percentage of loss, taking into account all the prior monies they received back as return on their investment or redemption. So investors who took money out receive no return until others catch up on them percentage-wise. And thereafter, they'll share as the tide rises and lifts all boats with everyone on a pro rata basis. Investors who took money out during the scheme typically fare better under a net investment distribution scheme over, I don't like that word scheme, but that's what they call them, over rising tide. To visualize it, if you put in $100 investment and you had received $90 back, as an investor, you have a $10 loss. You got 90 back, and you'll receive your distribution based on the $10 loss from day one under the net investment theory. But under the rising tide, where the receiver had sufficient funds to bring all victims up to 90% recovery, since that's what we're talking about here, that same investor will receive zero, since he or she's pre-distribution has already brought them up to that 90% recovery, and that's all that's being given out. The rising tide often results in meaningful distributions to the greatest number of investors, and that's often one of the largest equitable factors that the receiver and the court are looking at, which is to give a meaningful distribution to as many victims as possible. Also, other examples where you might use the net investment over the rising tide is where the receiver doesn't have reliable investment records. So there'd be no reason to do this to the penny kind of analysis as to when things kick in, and let's just look at the net losses as best we can figure them out in a claims process. That last statement method, rarely used in the United States, since it's based on statements with fictitious profits. It could also result in payments to net winners who were original investors, and therefore will benefit most from the fictitious growth that's shown on the statements. But most receivers and most courts will require the receiver to do an analysis of all three so that the court and the receiver can look at the different results and kind of double check as to what's the best, most equitable way to proceed with a great deal of discretion. Receivers and the judges and quite frankly, the agencies will weigh in as well, have to come up with the best distribution plan.
Thank you, Jonathan. Yeah, I think it's you've hit this very well and explained it thoroughly. And it's clearly there are cases that involve different approaches. And so the key is to think about what the appropriate approach is. I've used net investment. I've also used rising tide. One very helpful case that kind of nicely lays out what rising tide is and how it's implemented and whether or not to use it is a case called SEC versus Huber, which is a Seventh Circuit decision on which I was the receiver. But the key is go and take a look at what your options are and figure out the best way to apply it. Speaking of applying, thank you for applying yourselves to today's program. We appreciate your time and attention. And we are at the end of our program. I'm just going to pull you back to slide 6. That reminds you that you cannot go out and make important business decisions based on what you learned in this webinar. We are not your advisors. You're not our clients. This program is meant to provide general knowledge, which may be helpful when you select and work with advisors. I'd like to select our panel of superheroes, Chip, Kathy, Melanie, and Jonathan. If you do not see them around town wearing their capes, you can find them among the bios that are in slides 35 through 39. This concludes our webinar. Just going to take us down here to our final slides. And thank you for joining another entertaining yet educational production of Financial Poise. Whether you joined us in your office, your home, or another place and time, we hope you found the program out of this world. Look for Financial Poise webinars wherever better continuing education webinars are sold. And thank you for joining us today. That concludes the webinar.